Good morning. Well, sorry, good evening. And thank you for tuning in to the CAN TV, Cook County Bar Association's live on CAN TV. Tonight we will be discussing real estate law. I am an attorney. My name is Mika Thompson. I will be your host. And our guest today is the distinguished attorney Lewis Powell III. He will be discussing real estate law. Attorney Powell, will you give us a little background?
Reader's Digest version. First of all, I don't know about the distinguished part. We're going to do the best we can to bring some information that you can use. I've been licensed to practice for 26 years. Former member of Harold Washington, Eugene Sawyer's administration back in the day. I've taught law school at John Marshall since 1994. My practice consists of primarily of real estate, litigation, 501c3 organizations, corporations, and transactional matters. And I'm a former president of the Cook County Bar Association.
Thank you. We would like to take this time tonight to allow the audience an opportunity to comment and ask questions and give their opinion regarding real estate law. So please feel free to contact CAN TV at the number you see below on your screen, 312-738-1060. That's 312-738-1060. As you may or may not know, the Cook County Bar Association is the oldest association of African American lawyers and judges in the United States. And we take this time on Wednesday nights at 6 p.m. to discuss an issue of legal import or political significance. So today, as I said, we'll be talking about real estate law. Now, at this time, although I'm an attorney and Lewis Powell is an attorney, we don't represent your interest. If you need an attorney to address a particular interest or issue that we're not discussing today, please go to cookcountybar.org. As you see, it's pictured on your screen, and you click on lawyer referral, and you can see a list of attorneys that are qualified and licensed in the state of Illinois, and their phone number and contact information is listed, as well as the areas of laws that they practice in. Okay? You can also contact the Cook County Bar at 312-630-1157 and speak to anyone that answers the phone and ask for lawyer referral that way also. So you can either do it by web or you can do it by phone. Okay, so getting to the topic of discussion for today, real estate law, we want to talk about first, basically just give you some basic principles that guide Illinois real estate property here in Illinois, and our first question for Attorney Powell is, who can own real property in Illinois?
Well, an individual.
Okay.
An individual as well as a corporation, for example. I, Lewis Powell, can own property. Lewis Powell and Mecca Thompson, Attorney Mecca Thompson, we can own property together. And also a corporation can own property, and actually a partnership can own property.
Can a deceased person own property?
No.
No. Is there another way that their estate or something can own it?
Yeah, technically, when a person passes away, whether they have a will or not, technically they have what's called an estate. And the estate will consist of both personal property and real property. Real property would be the actual real estate. Technically, personal property, to be quite honest with you, is everything else. Money, furs, cars, things of that nature.
Okay. So we'll go back, if there's time, we will discuss more in detail regarding how estates can own property. But just as an overview, you can understand that there's three types: is the estate, the corporation, or individuals. Okay, how does one obtain title to real property?
It can be quitclaim. Now, usually it's obtained by consideration. And what is consideration? Really money. Really, when individuals purchase property from a person, they become title owners, owning the property with a deed and with title.
Okay. And what type of instruments are used to transfer title?
Okay, there's several. Because first of all, you're going to start with a deed.
Okay.
In order to transfer property, you have to have a deed. Now, there are different types of deeds. There's what is called a quitclaim deed. Now, ladies and gentlemen, you have to be careful with a quitclaim deed, because technically what a quitclaim deed is, it says whatever, using myself as an example, whatever interest I may have in a piece of property, I convey to you. Now, what are we talking about? Technically, I could quitclaim interest that I have in a piece of property where I only own half of the property. I mean, like tenants in common, where I have half ownership of the property. Now, you have to be careful what a quitclaim deed is, because a quitclaim deed is basically saying whatever interest I have, I convey to you.
And it doesn't have to be specific as to how.
It can be general. You have to be very careful. Let's talk about the different ways you can hold title. You can hold title what's called tenants in common. Using Mecca and myself together, we can own property together and tenants in common, meaning technically we own the property together. However, if something would happen to me, my ownership interest could conceivably go to someone else. How could it go? It could go by will. Okay. If I don't have a will, it'd be operation of law, but it wouldn't automatically go to Mecca. So again, tenants in common, you own the property by itself in its entirety, but in terms of my descendants, it will go to somebody else other than Mecca. Joint tenancy. Joint tenancy, ladies and gentlemen, is usually married couples.
Well, wait a minute. Before we leave in tenants in common, for tax purposes, if, for example, in Cook County, persons that own property in tenants in common, are they both obligated for the tax? Or
Yes.
Okay.
So
okay.
on your tax return, your accountant will figure it out in terms of how to apportion the ownership of the property, how to apportion how the taxes are being paid, because that's a write-off, and how to apportion the mortgage payments.
Oh, we have a caller. Caller? Hello?
Yes, good evening. How y'all guys doing? And first of all, happy holiday to all your listeners and also to you too.
Thank
and
you.
a safe one. Listen, on the quick deed, if you purchase the property and if there's any liens or any violations on it, do you inherit it or do it stays with the person that had the property prior to it? Or then that's what they call maybe you should always do your research. Did you understand the question I was asking?
Very good
All right,
question.
let me get out the air so I can hear your response, and thanks for taking the call.
Reader's Digest version. You get what you buy. If you purchase property by quitclaim deed, that means whatever goes with the property, liens will go to you. Now, but again, with a quitclaim deed is whatever interest I have. Now, ladies and gentlemen, caveat: if you're buying property with a mortgage, even if you wanted to, the lender is not going to allow you to purchase property with their money with liens on it, such as code violations, so forth and so on. However, if you're buying property with cash, you can do what you want to do. Meaning it's quite possible to buy property, and it happens because sometimes you get property at a discount. You know it may be a lien on there. You may take care of it after the fact. It could be a code violation. It could be a judgment. A judgment will act as a lien. But the Reader's Digest version is if whatever property, whatever condition of the title, when the seller conveys it to you, you are stuck with it, and not the seller. The seller is completely out of the picture.
Released from it. Okay, and that can happen a lot with those quitclaim deeds.
It can happen. Now, what happens in building court, fast forward, a lot of times people in building court, they may be in trouble. They may sell the property at a discount to a buyer. It happens all the time. Caveat: in building court, what the city of Chicago does, which is very clever, they will keep the seller tied up in the litigation until they're comfortable that the buyer can rehab the property. So what are we talking about? It is not uncommon for a property being built in court and a buyer will come in, usually a rehabber, someone in the nature of doing that business, will come in and rescue the seller while the property is still in litigation. But again, the court is going to hold both parties responsible, both the buyer and the seller, even though the seller has sold the property. Okay, now that's the contradiction of what I said earlier. Usually when you sell the property, you're out of the picture. But for City of Chicago building court purposes, You're still in there until they decide to release you.
Until they decide to release you. So any code, the court is looking for the property to come up to code.
Exactly.
Okay. So whatever those violations are, whether they're monetary or just what do they call them with the
Clouds of the title.
exactly. So they're going to wait and see basically until it gets up to code. Interesting. That's a good question. Thank you, caller. Okay, so that is dealing with the quitclaim deed title type of title. And is there another type of title? Or do you want to go back to the tenancy?
Warranty deed.
Warranty deed.
Warranty
Okay.
deed, ladies and gentlemen, is the best possible title because technically warranty deed represents that you have superior title to anybody.
Okay.
So if somebody comes along with a quick claim deed, your warranty deed technically should trump it.
Right.
Okay, but warranty deed is the best possible deed. A trustee deed is just as good because basically these deeds are warranting that you have full ownership with no restrictions. Again, a quitclaim deed, just to recap, whatever interest I have, I give it to you.
And whatever liabilities I have.
Exactly. With a warranty deed, I'm representing to the world that I have superior title against anyone.
And that's the person that is selling the property.
That's
because
right.
He's representing. So the buyer, if they take the title with a warranty deed, they then will have a cause of action if they find themselves in building court, for example.
Well, yes, if it was not disclosed.
Okay.
Because again, it's buyer beware. Now it's quite possible to buy property that's in building court and convey it with a warranty deed.
Mm-hmm.
Happens all the time. But it's buyer beware because if you're in that type of situation, you should be aware by looking at the title report to see the clouds on the record, which we're talking about imperfections on the title, such as a building code violation or a building code case. It's called a lis pendens. Whenever there's a legal action regarding the property, whether it be building court or foreclosure, it pops up under technically what's called a lis pendens, which shows up on the title report.
And so attorneys often will protect their client's interest and reduce the client's liability by filing with the recorder of deeds a lis pendens notice anytime the real property is caught up in litigation.
Exactly. And even if they don't, to be honest with you, it's going to pop up anyway because the title company usually is going to do a thorough review of the public records, and a lawsuit is a matter of public record.
Right. And so if you're purchasing property, it's even if you're not using an attorney or a realtor, it would be in your best interest to utilize a title company for the closing.
That's the understatement. The fact of the matter is this. You be doing yourself a disservice by not using an attorney. Now, granted, I'm in the business of doing real estate, so it's self-serving, but to be honest with you, penny wise, penny foolish. You need an attorney that knows what they're doing. Also, as counsel stated, the purpose of a title company is to guarantee the quality of the title. Now, again, if you want to buy property with a lien, you can do that, with the exception if it's not a mortgage involved. As I said earlier, a lender is not going to allow you to use their money to purchase a piece of property with any liens, however, or any old taxes. However, if you're paying with cash, and it happens quite frequently, and you're getting property at a discount, it's quite possible you may buy property with liens on it. You may buy property with back taxes. It's just buyer beware. Your best bet, if you're buying property with back taxes, is what's called a estimate of redemption. That way you know the drop dead date that you have, the last day that you can redeem the taxes.
So yes, I agree. It's much better to seek out the advice of counsel before dealing in any type of purchase or sale of real property. Okay, so we talked about the types of title. You have a quitclaim deed, a warranty deed. Is there any other types of title title instruments you would want to discuss?
We talked about trustee deed, which
Trustee.
is fine, which is simply if property is held in trust. It's what we call in the business a legal fiction. You, the owner, you own the trust. Technically, the trust owns the property, but you have the right of direction, meaning you tell the trust what to do. What we're talking about. You can direct the trust to sell the property to whoever you want to. But again, it's a legal fiction. You own the trust, and technically the trust owns the property. Having property in trust is a very good discipline, because if the property is in trust, it is technically not in your estate, because technically you do not own it. And if the property is in trust, you can have it go into, you can have the beneficiary being whoever you want. It passes outside of your will, and all the trust, for example, Chicago Title and Trust, all the trust company would need, ladies and gentlemen, is for whoever is the beneficiary to bring a certified death certificate, and then they will do the necessary mechanical action to have the trust convey the property to you. Very, very simple, not complex. Holding property in trust is a very good discipline. It prevents people from arguing over property.
But you do need to consult an attorney and make sure that you, if you're holding a title property in trust, that you make the proper payments to the title company, if that's who's recording the trust, or a bank, whoever's holding it,
Exactly.
acting as a trustee, and get the proper advice with regards to listing beneficiaries and making changes to the beneficiary list. We have another caller. Hello, caller, you're on the air.
Yes, the same caller. Now another question about that. Will any of that be deductible on your income tax if you did purchase anything with those codes or violations or anything like that? Can it be deducted on your tax if you do purchase it? Let me get out there again so I can hear your response.
Good question. Neither one of us are accountants, but I can tell you this. When you buy property, that's a deduction. Now, I don't think that you can deduct because there's a lien on the property. However, if you pay off the lien, that's an expense. And we all know expenses as they relate to property is a write-off. But to answer your question, just because there's a lien on the property, that in itself is not a write-off. However, you as the owner of the property paying off the lien, that is a write-off.
And then if there's any type of property taxes that are attached to the property, and you you pay those, that can be a deduction.
Absolutely. The key is you have to pay it.
Right, you have to pay it. Okay, so we talked about the types of documents that can be used to transfer title. Now I think we should go on and complete your conversation and discussion regarding the tenancy and the types of tenancy and methods in which people can hold title. So you talked about tenancy in common. I think you were going on to the next one.
Joint tenancy.
Right.
If joint tenancy, if Mecca and myself own property, is joint tenancy. Again, we own the property as a whole. And if something would happen to me, automatically, even if I had a will stating it should go to such and such, by the property being in joint tenancy, that trumps that. Mecca owns the property by herself. Again, joint tenancy is called with right of survivor. Right of survivor. There's another way of ownership. It's called joint tenancy, tenanted by the entirety. Ladies and gentlemen, there's a good discipline if you are married and this is the marital residence to have it joint tenanted by the entirety. That prevents, to a certain extent, because people get sued all the time, that prevents creditors from making, if something go wrong, that prevents creditors from making a beeline towards your property in terms of leaning it up and trying to foreclose on the lien. Because you technically, if you know what you're doing, if someone places a lien on their property and they know what they're doing and you don't pay off the lien, they can really force you to pay off the lien or get the property.
Exactly. So is there any now, currently, are there any restrictions regarding marriages of same-sex couples with regards to their ability to hold property and tenancy by the entirety?
That's a new emerging area of the law. To the best of my knowledge, no, because since this same-sex marriage is now recognizable, it would just seem to me, logically speaking, that they have the same rights in terms of tenants by the entirety.
Yes, the Supreme Court has made it clear that states cannot discriminate against individuals of the same sex. So any rights that are available to heterosexual couples are now available to same-sex couples. But as Attorney Powell stated, that is a very new ruling by the Supreme Court, and all the states have different laws with regards to how they're doing civil unions versus same marriages by same-sex couples. And we do have a new president. You need to stay tuned, right?
Absolutely.
We need to stay tuned.
That's
with
an
regards to that.
understatement.
So you heard it here first. The Supreme Court has ruled, and that ruling is still valid, but we do need to stay tuned with regards to same-sex couples and their rights with regards to their ability to hold title as tenancies in the in entirety. Okay, so just quickly, and this is a brief overview, how does divorce affect title in Illinois?
Okay, usually when a divorce, again, this is not my area of law in terms
Right.
of divorce, but I do know this. Usually when there's a divorce, it's going to trigger a couple of things. And usually a lot of times if someone is married, chances are that both parties may be on the deed, both parties may be on the mortgage. Not all the time, but chances are they will. Usually with a divorce, it triggers someone trying to get away from the property, for lack of a better term, or someone trying to force the other person to disinvest their interest of the property. So what the divorce will usually trigger is usually probably as part of the divorce decree, one spouse quit claiming their interest to the other spouse. Now, a couple caveats with that. As long as there's a mortgage on the property, ladies and gentlemen, don't just automatically quit claim.
Right.
Okay, because quit claim is technically a transfer of ownership. And the lender will catch that, and unless you've gotten permission of the lender, they can say that the note is due.
Right.
When you buy property, there's a mortgage, the mortgage is recorded, the note is not.
Right.
And technically, they sue you off with the note. So caveat, if you get divorced, you're obviously going to use someone, a use attorney knows what they're doing. Part of the divorce settlement is going to state how the property is going to be divided. If people have joint ownerships on it, joint ownership and interest in the property, that can be taken care of. Again, as part of the divorce decree. Again, as part of notifying the lender that one person is going to quit claim their interest in the property to another. A lot of times, the spouse that's remaining owner of the property very well may refinance and take the other spouse out, meaning paying off the existing mortgage and he or her himself taking over sole ownership of the property.
Now you have to recognize that there are differences between owning title and financing a real property. So, Attorney Powell, can you explain the difference between a mortgage and the deeds that we have already discussed?
Okay,
Right?
deed designates the ownership. It says such and such conveyed the property to such and such.
On
That
this
is the
date,
deed.
on this
Right.
time, and
The mortgage,
location.
okay, the mortgage is the obligation stating who the lender is, actually stating the amount of the mortgage and the payment terms, so forth and so on, stating the obligation that the buyer has to the mortgage company.
And the security interest.
And the security is, remember, a property is a secure transaction, not an unsecured transaction, because when you go to a closing, your attorney should point out to you this is a secure transaction, meaning if something goes wrong, the collateral is the real estate themselves,
Right.
and if you fall behind, that triggers foreclosure.
Right. And it goes through, the mortgage really gives you a details with regards to the security interest.
Absolutely.
And what will happen if you fail to pay as far as the security interest? If there's a additional security interest, whose interest comes before what interest? And so you're really focused on the security interest with the mortgage, and that's why it needs to be recorded. Whereas a note, it may not be recorded, like you said, with the recorded deeds. So the note is the one that details all of the money and the loans and the financing. Okay, so that's the difference. And so when you do the marriage, the divorce decree handles the title.
Absolutely.
The title.
Usually.
Okay, so we have had a very good discussion today regarding real estate law here in Illinois, and we did give the Reader's Digest version with regards to ownership interest. We thank the caller that called in and asked some questions and got some answers regarding ownership rights and interest here in the state of Illinois. Feel free to call in next week, 6 p.m. on Wednesday, and we will be discussing child support. And so thank you again for calling in, And thank you, Attorney Powell, for answering our questions. This concludes our show tonight, and we'll see you next week on Wednesday at 6 p.m., same time on CAN TV.